Another fatal shooting in Minneapolis claims the life of Alex Pretti. Was this a valid act of self-defense by the federal agents? And do you buy the narrative being put forth by the federal government? I have some thoughts. Stay tuned. This is attorney Andy Marcantel from the Attorneys for Freedom law firm, and here we are again. Just a couple of weeks after the shooting of Renee Good that was highly publicized throughout the country, another fatal shooting happens in Minneapolis, this time to confrontation between an armed citizen and a federal agent, and the feds are claiming that this shooting was a valid act of self-defense. I have a lot of thoughts on this, but just to keep in mind who we are. We're a self-defense law firm. That's all we do. We have a national practice here at Attorneys for Freedom where we specialize in self-defense cases. And we're the only law firm that exclusively handles self-defense cases in the United States. So whenever one of these things happens, we get lots of questions. People want our feedback on whether we agree if it's self-defense or if it's not self-defense. If you guys have been following us for a while, you know a few things about our law firm. First of all, we are not beholden to either the left or the right politically. We call them like we see them. We're lawyers. We're objective. We give objective legal analysis. That's what we do. We're also not anti-cop. We're not anti-all police officers or agents. In fact, we are pro-good cop and pro-good agent and very, very anti-bad cop and bad agent. We are also extremely strong proponents of the Second Amendment as it applies to everyone, regardless of your political affiliations or preferences. Every American has an absolute right to defend themselves with a firearm if necessary. And with all of that in mind, I can tell you that when it comes to this incident, there's some really troubling rhetoric coming out of the Trump administration right now that, if not outright rejected by the 2A community right now in this pivotal moment, threatens all of our freedoms. So if you're one of those people that just has a blind affiliation to one political party or the other, well, first of all, that sucks. I feel sorry for you, and I hope you develop some critical thinking skills such that your opinion can actually be supported by whatever the evidence shows. But I strongly encourage you not to immediately click off this video as soon as you hear something that rubs up against whatever's in your preferred political narrative, because you, in fact, are the people who need to hear this the most. Now, before we dive in, remember, we don't have all of the evidence yet. Yes, there are 5 videos at the time of this filming that have been released to the public. I've reviewed all of them multiple times, and that's going to help me form my opinion today. There's also a little bit of evidence coming out in terms of witness statements, and bottom line is we're probably going to see a lot more. So regardless of what I'm about to analyze for you, I proudly reserve the right to change my opinion completely if it's warranted by the evidence, and you should too. And also, to keep it in perspective, people, you gotta maintain your morality when you're analyzing these types of things. Don't sacrifice your morality for political points. A human life was lost here regardless of their political affiliation. Maybe you completely disagreed with why that person was out there that day. Maybe you fully supported why they were out there that day. Nobody should be celebrating at a time like this for political reasons. It's ridiculous, it's not classy, and it's immoral. So keep your analysis objective. Don't let your hate of the other side cloud your reason. Why did this shooting happen? Well, before we dive into the specific facts for our legal analysis, let's back up a little bit and look at the 30,000-foot view of the temperature, of the climate going on right there in Minneapolis, Minnesota. And I'm not talking about the weather. I'm talking about the political climate. We have Governor Walz out there basically saying this is an existential crisis, a battle of good versus evil. We have the mayor out there saying to ICE agents, get the F out of Minneapolis. The elected officials over there are framing this as an existential crisis. The very freedoms of the citizens of Minneapolis are now on the line. Is it any wonder why the tensions are so high? On the flip side, the Trump administration characterizing the protesters as domestic terrorists who are out there to kill all the ICE agents. With all of this heated rhetoric, we should expect more of the same until this stuff calms down. Both sides should strongly consider lowering the temperature of their rhetoric, or else we can only expect to see more of these types of confrontations, not fewer. Inevitably, when there's more confrontations, when ICE agents are squaring off against citizens in the streets, it's going to end in tragedy. So the people out there on the streets protesting that day, including Mr. Pretti, simply believed what they were told by their elected officials. They believed it in good faith. They believed it in their heart. They believed that they were part of a battle of good versus evil. Whereas the ICE agents have been conditioned now by their very administration to look at the people protesting them as domestic terrorists and predictably are acting as if they're dealing with terrorists. So with the political leaders on both sides fanning the flames of this conflict, we're only going to see more of this until both sides tamp it down. But of course, both of the political parties are using the citizens as pawns right now, as far as I can see, to gain political capital for their side. The feds are using this to try to justify invoking things like the Insurrection Act, to bring in federal agents in order to quell the rebellion going on in the city, whereas the other side is essentially casting all of the federal agents as the Gestapo, the stormtroopers of an out-of-control government here to take us all over, and are trying to drum up support for the next election cycle. It's disgusting. It's gross. We should see what's going on here, people. We, the citizens, lose in these types of politically fueled conflicts that both sides of the political spectrum, leaders on both sides of the aisle, are fanning the flames into. All right, with all of that background in place, let's talk about what happened in Minneapolis on January 24th, 2026, involving the shooting of Mr. Pretti. So like I said, so far there's been 5 videos as of the date of this recording that have been released to the public. I've also seen reports as of the day of this filming that there are some yet to be released officer body camera videos, and I'm very interested to see those. Those are not out to the public yet, but hopefully those can help shed some light on some additional details. And I fully expect there might be some more floating around out there. We might very well be getting more evidence in this case, and this seems like a great time to once again reiterate, if new evidence comes out, I reserve the right to change all of my opinions that I'm about to give you, and you should too. Contrary to this belief that's really taken hold in the age of the internet, changing your mind in the face of new evidence is not a sign of weakness. In fact, it's the very thing, by definition, that makes you a reasonable person. You follow the evidence and you only hold an opinion that is supported by it. More people should take this tact when they're analyzing situations like this. So on January 24th, 2026, Mr. Pretti was at a protest. There was an active ICE operation going on at the time where they were trying to apprehend somebody from a donut shop who had a violent criminal record. And he happened to be an illegal alien. That's why ICE was involved in the operation. Federal agents were being accosted by protesters, and Mr. Pretti was present with his cell phone in hand and an empty other hand filming the operations. At one point, you can see in the video, an ICE agent shoves a woman, and he maybe repeatedly shoves her, and she ends up on the ground. Mr. Pretti then comes over and seems to position himself between the agents and the woman. At that point, they spray Mr. Pretti with a chemical irritant, and Mr. Pretti is taken to the ground. Now, we cannot tell exactly what was being said by all of the parties from the video, and I'm going to explain why that ends up mattering in my legal analysis. But long story short, federal agents take Mr. Pretti down to the ground, are searching him, and at one point, one of the agents finds a firearm in Mr. Pretti's waistband, removes the firearm, and then agents start yelling, "Gun, gun, gun!" And within mere seconds of disarming him, removing that firearm from him, one of the agents shoots Mr. Pretti. Several of the other agents appear to join in. There are approximately 10 total rounds that are fired, and Mr. Pretti dies as a result. It's not clear which one of the federal agents fired which round. Hopefully ballistics will sort that out eventually. And that, in a nutshell, is the basics of the encounter, but there's a whole lot to analyze here. So before we dive into the specific facts, let's make sure that we understand the standards of review for self-defense for federal agents. And we got to run it through the same analysis that we always do in self-defense cases. I don't care if you're a federal agent effectuating an arrest. I don't care if you're a civilian. The same must be true, which is, as you've heard us say many times, at the moment he pulled the trigger, did the federal agent in question have a reasonable belief that he was at an imminent risk of death or serious physical injury? That's all that matters at the end of the day. As with most high-profile cases, there's a lot of irrelevancies floating around this case. There's a lot of red herrings that I'll flag for you as we go through, but that's a really important place to start, is the baseline self-defense analysis will apply to these agents the same way it would to any civilian in a similar situation. Additionally, this case has come up in our analysis before. Graham v. Connor sets out the reasonable officer standard. That's a United States Supreme Court case that basically says we don't require perfection from our officers and agents. We just can't. They wouldn't be able to do their job if we required them to act perfectly in all situations, lest be held to some sort of criminal liability. Instead of that, we posit what we call a reasonable officer standard. That is, if a reasonable officer in their shoes would have also used deadly physical force in that situation, we're going to say it's a good shoot. And all that matters here is what's actually going on in the agent's mind. We call this the mens rea, or relevant mental state. It doesn't matter whatsoever what Mr. Pretti was intending to do or actually was doing. In fact, all that matters is what's going on between the ears of the officer at the time that they pulled the trigger, even if they were reasonably mistaken about the facts. This is why we have a reasonable mistake of fact doctrine as a justification defense in every single jurisdiction in the United States. That is, even if the officers were mistaken about the imminency of the threat, or whether there even was a threat at all, if that mistake was reasonable, they're going to be able to claim reasonable mistake of fact in their self-defense case. That's a full defense. So given that all that's important at the time of the shoot is what's going on in the agent's minds, let's quickly dispense with a falsehood that's been floating around this case. Well, hold on. He was completely disarmed at the time of the shoot. They took the firearm away and then they proceeded to shoot him. So given that he wasn't armed, he wasn't presenting an imminent risk of deadly physical force, and so case closed. It's a bad shoot, right? No, that is not the standard. What matters is what the agents reasonably believed at the time that they pulled the trigger. Even if they were completely mistaken, even if that belief was erroneous, if it was reasonable, then it's going to be a good shoot. So the disarming of Mr. Pretti is only relevant if the agents that fired knew about the disarming and knew that he actually didn't have any firearms left on him and chose to shoot him anyway. That indeed would be a disproportionate use of force, and they wouldn't be facing an imminent risk at that point. They would have a belief that they weren't facing that imminent risk, and that would be a bad shoot. But that's not what the defense argument is going to be here. Now let's talk about some other things that seem apparent from the videos that have been released so far. It does not appear to me that Mr. Pretti at any time brandished his firearm or touched his firearm or gestured towards his firearm in a threatening way. Rather, it looks like he was carrying it in his waistband. It was unknown to the agents until they had him on the ground and were searching him and found the firearm. There are a few freeze frame images that are floating around on the internet that purport to have him with a cocked arm, kind of like this, looking like he was going for the firearm. But if you look at the videos in context, it's very, very difficult to ascertain that. The defense attorney might try to argue that a couple of these motions indicated to the agents that he was going for the gun, so far unsuccessfully. That'd be a tough argument, in my view, in the context of the video, where it does not obviously look like he is trying to go to the back of his waistband, which is where the firearm was recovered, in order to use it against the agents. But that's a question for the jury. But here's a really strong piece of evidence in the case. What about when the agents were yelling, "Gun, gun, gun"? The idea here is that as soon as they searched and found that firearm, they started yelling "gun, gun, gun" in order to alert all the agents that there was a gun, an active gun now, involved in this incident. And so other agents could claim that when they heard that yelled by other agents, gun, 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 they interpreted that, maybe erroneously, to mean he's going for the gun. We are in fear of our lives right now, and so we need to be rescued. We need to prevent damage to the public. And so that was the idea in the mind of the person who fired first. But this part's really important. When the agents found the gun on him, several of the agents started yelling, gun, gun, gun. Now, if I was the defense attorney and I was representing the agent who apparently fired the first shot, I would put him on the stand and I would expect the testimony to be somewhere along the lines of, now, when you heard your fellow agents yelling, gun, 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 what did you interpret that to mean? And I fully anticipate answer back is going to be, I interpreted that to mean that there was an active threat of deadly physical force to my fellow federal agents and myself, and that the guy was either handling a gun or pointing a gun or going for a gun, threatening to shoot the agents, threatening to shoot members of the public, and I interpreted that to mean that there was an imminent risk of deadly physical force. But hold on, might say a prosecutor if this case was ever tried. This could be negligent conduct, and there's different levels of homicide that might apply in any given homicide case. We have levels that reflect the amount of mens rea. The severity of the mens rea affects the severity of the crime. So to give you an example, imagine the worst case scenario of a premeditated murder. Somebody plans out the killing of somebody else. Premeditated murder, we also call it first-degree murder, requires premeditation and intent. Then if you move down a level to second-degree murder, this is an intentional killing. It requires intent, but it doesn't involve premeditation. And there are actually several different brands of second-degree murder that are statutorily recognized throughout the United States. Some of the statutes describe the mens rea as kind of a callousness or depraved heart or wantonness to the safety and well-being of others. That's second-degree murder. It's not a planned-out murder. It's something that was intended, happens in the moment, but doesn't rise to the level of premeditation. Moving down yet another level, we have manslaughter. Manslaughter is not an intentional killing, but it's a conscious disregard of a known risk. Think somebody who gets completely intoxicated, gets into their car, goes driving down the street, and then wrecks into a minivan and kills a family of 4. They didn't intend to cause that accident, but this is such an obvious risk that a prosecutor is probably going to argue they committed 4 counts of manslaughter. They ignored an obvious known risk and a death resulted. But to move down even one more level, we have a crime that's recognized in most jurisdictions called negligent homicide. Negligence is that mens rea requirement that basically says, you made a mistake. You made a big oopsie. You were negligent. And because of your negligence, somebody's death occurred. So let's say that this agent was in the moment and interpreted erroneously the gun, gun, gun to mean that he actively has a gun in hand and he's going to try to shoot us and everything like this. That could just be an error. That could just be a mistake. And if it's just a good faith mistake and a death still occurred, well, it could still rise to the level of a negligent homicide. It's a lower level homicide, but a very serious crime nonetheless. And so a prosecutor might argue, well, hold on, you made a big mistake there, agent. And so that rises to the level of a negligent homicide. But charges that have mistakes as their mens rea are rife for challenges from good defense attorneys based on that reasonable mistake of fact doctrine that we talked about earlier. A reasonable mistake of fact is, by its very nature, involves an erroneous misunderstanding of what's going on in the situation at the time. The question is simply, was it a reasonable mistake of fact? If a reasonable mistake of fact, we're going to have a good defense at trial on a justification defense. But if an unreasonable mistake of fact, in other words, if a jury is convinced that by hearing gun, 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 what they meant to say was, I got a gun from the suspect rather than he's actively got a gun and is threatening us with it, then it's an unreasonable mistake of fact. That's going to be a negligent homicide. Remember what we talked about in our Renee Good shooting video, which is you never know what a jury's going to do. And if you need proof of that, simply look at the comments section on any of these videos. And for every 10 comments you see that believe this was cold and calculated first-degree murder, you're going to see just as many comments saying, no, this was completely justified shooting. The guy shouldn't have been out there antagonizing these agents in the first place, and so therefore this was a completely justified shooting. All those people could be in your jury pool. You never know what you're going to get. And these comment sections on YouTube are a really good illustration of how two otherwise very reasonable people, when in their politically motivated ideological mode, can look at the same piece of evidence and reach two completely different conclusions. You never know who's going to be on your jury. Now, once again, there are things about a certain jurisdiction that we can use to predict who's going to be on your jury. So, for example, if this were to go to trial in state court in Minneapolis, I would strongly suspect there's going to be a larger amount of people on the jury pool who are in that first category, the clear, cold-blooded first-degree murder camp, than in the justified federal agent shooting camp. But you never know who's going to be on your jury, and all it takes is one of those people who are on the justified side to hang the jury. So you never know what you're going to get in a jury pool. But regardless, let me ask you a question that I want you to contemplate, especially if you consider yourself a responsible firearms owner, and many of you watch our channel. Do we want this to be the standard, that the agents yell gun, 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 and that's enough in and of itself for them to shoot a otherwise law-abiding gun owner just because they found a gun on their person during an interaction with the cops? That's not the standard I want. I think that's an outrageous standard. Just because they yell gun, gun, gun shouldn't give them automatic license to shoot you, especially when you've already been disarmed. And so this is really a question of what should the standards in training be. If you've got a gripe with this, you may have a gripe with the training of these agents or officers at a state level. But I digress. The defense attorney in these agents' cases should focus on the split-second nature of these types of interactions. Remember, the case law does not require us to hold these agents to a standard of perfection. They need only be held to a reasonable officer, in this case, a reasonable agent standard. Would a similarly situated agent who pulled that trigger, would they have believed that they or one of their fellow agents was at an imminent risk of death or serious physical injury? Now, after the first shot is fired, it appears that several agents then start shooting at Mr. Pretti, leaving him dead on the ground. Now, just because there was an initial shot, even if that initial shot was justified, it doesn't necessarily mean that any agent that joined in is going to be off the hook. The same analysis always applies. At the time that they pulled the trigger, did they have a reasonable belief that they were at an imminent risk of death or serious physical injury? Now, you have to temper that with their training. Agents are trained that once the shooting starts, you need to shoot until the threat is neutralized. So no doubt that if other agents, not the guy who shot first, but the other agents were prosecuted, they're going to be relying on their training. And you can bet that the defense attorney is going to bring in an expert that talks to the jury and educates them about police and federal agent training. And here's when we start shooting, and here's what we were trained to do. And then there's also delay time that it might take to stop firing. And so they might bring in an expert to explain to the jury that the subsequent shots were an involuntary act. It takes your brain a certain amount of time to absorb the fact that you're facing an imminent threat, to respond and neutralize that threat, and then for your brain to process that the threat has actually been neutralized. This is an expert explanation that the defense can bring in to explain to the jury why there were approximately 10 shots that were fired. Now, what about the argument that Mr. Pretti illegally injected himself into this situation with the federal agents? So it looks like the federal agents were there to enact a valid operation where they were trying to apprehend a suspect, and Mr. Pretti came and injected himself into the situation when he saw the ICE agent push a woman. And so it looks like people argue he was trying to be a good Samaritan. The flip side of that is, we don't need your help. We as the agents don't need the citizens to come and involve themselves in our operations. And the response from the other side is, wow, that's a very callous point of view. You want citizens, when they see what they interpret to be as a total violation of their fellow citizens' rights, or maybe their fellow citizen is being unjustifiably brutalized, are we to simply sit by and watch and just watch these agents brutalize our fellow citizens? So there are arguments on both sides of this, but I'll tell you this right now. This is mostly a red herring in the legal analysis of whether this was self-defense. Because all that matters at the end of the day, it doesn't matter how Mr. Pretti got there. It doesn't matter how Mr. Pretti ended up in this situation and ended up tussling on the ground. All that matters at the end of the day is at the time that the agent pulled the trigger, did he have a reasonable belief that he was in imminent risk of death or serious physical injury? So mostly this is a red herring, how he ends up there in the legality of injecting himself into this situation, even if it was undisputed that Pretti was violating the law with what he was doing, kind of like it was with Renee Good. It was undisputed that she was blocking traffic and that she was not opening her door when instructed to do so by the agents. Mr. Pretti, even if he was arguing with the agents, the current case law is that you don't get to resist even an unconstitutional arrest. So let's assume that the agents were just completely violating his constitutional rights, that all he was trying to do was be a good Samaritan lawfully for this woman, and the agents just ripped him to the ground illegally and started beating him illegally and everything like that. Well, even that is irrelevant because, as I mentioned, you don't have the right in this type of a situation to resist even an unlawful arrest. You bring a civil rights claim to square that away. You don't resist in the street. But all of this is mainly a total red herring because it doesn't matter why he got into that situation. All that matters is at the time that the agents pulled the trigger, whether or not they satisfied all of the requirements for imminent self-defense. Now, here's another interesting theory that I've seen proposed in defense of the agents. There's a theory floating around there that the first shot that was fired was not actually by the agent that we've been showing in the video, but rather it came from Mr. Pretti's gun after the gun had already been removed from his person by the other ICE agent. And there's some still frames floating around on the internet. I haven't seen anything too convincing that this actually happened, but this is a really interesting theory that would potentially absolve the agents of any sort of criminal liability. Remember, even if they're wrong about the imminent risk of death or serious physical injury, as long as they had a good faith belief that that was the case, they're going to be justified to use deadly physical force. So the theory here is that, look, basically what happened is the agent removed the firearm from Mr. Pretti. There was some sort of an accidental or negligent discharge, and then the other agents believed that Mr. Pretti was shooting at them. So they responded in kind. So it was a big misunderstanding, but it was a good faith misunderstanding because any agent in that situation, when they heard the shots, they're hearing gun, 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 and then they heard the shot, they are going to immediately assume that they're under attack. So interesting theory, but I'm extremely skeptical that it's true, and here's the reason why. If it were true, the good news for the defense would be it would be extremely easy to prove. Why? Because the round matching the gun would be on the scene. Now, I'm familiar with this firearm. This is the Sig Sauer P320. And this firearm, if you're a gun person, might be familiar with it too, because there's been a lot of controversy in the news surrounding this particular firearm, particularly with them going off when they're not supposed to be going off. They've been called accidental discharges, negligent discharges, things like that. It is attributed oftentimes to what the public perceives as a manufacturing defect with this particular firearm, that they tend to go off. And when all this controversy was going on last year, I was asked to appear on a couple different media outlets and podcasts to discuss the potential civil or even criminal liability one could have if they knowingly carried a firearm they knew to be defective and then an injury resulted. Now, of course, in this situation, in this second-by-second thing, there is no reason whatsoever to think that the agent who removed the firearm from Mr. Pretti had any knowledge of this particular firearms deficiencies, but that is being proposed as a possible reason why the firearm kind of went off on its own. It's that pesky Sig Sauer P320. That thing is known to have big problems in it, and so maybe that's what happened. But once again, this would be extremely easy to prove by the defense because the round would be on the scene. And presumably, they would find the round, they would match it to the Sig Sauer, and then boom, they would have their answer of exactly what happened. Now, as you guys probably know right now, the Trump administration is going through a firestorm of PR because of this. It's a huge, huge, huge issue. This shooting is not popular with the public in most circles. And so if they had the ability to quickly and easily put out the fire, it seems like they would have done it. If I was in charge and it turned out that this is how this shooting transpired, first of all, the agent probably would have told somebody about it by now. But even if the agent hadn't told anybody about it, they would have found the round matching the Sig Sauer on the scene. If I was the one in charge, I'd say, get that round to ballistics as soon as possible. We got to put out this PR nightmare fire that's going on right now and show them what actually happened. So given that this problem could be solved by the Trump administration so easily if it did happen, I'm very skeptical that this is the way that it played out. It's an interesting theory. And of course, if a new video or any new information comes out, like a ballistics report or something like that showing that this was the case, I'm going to modify my opinion accordingly. Now, will these agents be charged with a crime? Maybe, but not likely. The reason is the same issue that we analyzed in the Renee Good shooting case, which is the federal supremacy clause. This case involves federal agents doing federal duties and therefore, quite arguably and probably, falls under the federal jurisdiction of the federal criminal court. What happens if this case gets removed to federal criminal court on the defense attorney's motion? Let's say that they're charged in state. The defense attorney, as long as they're not asleep at the switch, is going to file something saying this is all federal jurisdiction stuff and needs to be kicked up to the federal prosecutor's office. Well, guess what? That federal prosecutor, they answer to the DOJ, the same DOJ that has come out very, very quickly after this incident with statements of support and justification saying it's valid self-defense. I am very skeptical that that same DOJ will turn around and prosecute these guys. And then to complicate matters further, for anybody who wants to see these guys prosecuted, is that once they're in the federal system, this now falls squarely within Trump's federal pardon power. And we already know Trump's already come out with a strong statement of support and said, oh yeah, this was completely justified. This guy was an agitator, this Pretti guy. He had scary loaded magazines. And so what's the deal with that? You know, he must have been there for nefarious purposes. And so given that it would be in the federal system now, Trump could swoop in at any time and grant a pardon. So looking pretty good if you're one of these agents that you're probably not going to get prosecuted successfully. Now, there's a wrinkle to this, because some state officials and even a few federal prosecutors I've heard analyzing the incident who are incensed about this and feel that this is unjustified homicide have said, you know what we're going to do is we're going to wait until there's a regime change. We'll wait until the next president's regime comes around. There's no statute of limitations on some of these homicide crimes, and there's very long statute of limitations for other ones. We'll just wait till Trump's out of office, and then we'll just wait until that time, and then we'll charge him with a state crime, and we won't be too worried. And if it gets removed to federal court, we'll have a different Department of Justice to prosecute the people. So you might not be completely out of the woods just because the team that's currently in the White House happens to be on your side. This happens to be one of the biggest problems when political parties don't have principles anymore. We can't have any sort of predictive power on who's going to do the right thing. Really, both sides should be unified in trying to determine, based on the facts and evidence, whether or not an unjustified killing took place here. Now, rest easy, everybody. The federal government has assured us that they are thoroughly investigating the matter and will give us all the information very soon. But does anybody believe for 1 second that the federal government is going to conduct some sort of an unbiased investigation here? Don't we have every reason to believe that that's not the case? In fact, right after the shooting, within hours of the shooting, Kristi Noem and several others in the government came out and said, oh yeah, this was as clear as day, self-defense. They gave us the conclusion ahead of the investigation. And then after giving us the conclusion, they're now saying, but don't worry, we'll investigate it in order to affirm our own conclusion that we already gave you. This is literally just a case of the federal government is going to investigate the federal government to figure out that whether what the federal government did was okay. So I am not confident that we're going to get any sort of an unbiased investigation here into this. Of course, as you probably know, the state attempted to do their own investigation and the state authorities were shut out by the feds. And if you don't like this, you get to blame that supremacy clause thing that we were just talking about in the previous section. So I am not confident that we're going to get any sort of a fair and unbiased investigation here. And here's why that matters. In the law, we have a really important ethical concept. It's called the appearance of justice. The idea of the appearance of justice is we want to make sure that when different agencies, such as prosecutors or law enforcement, are investigating somebody, it's being done in a fair and unbiased manner. And we do a lot in our criminal justice system in most contexts in order to try to maintain this appearance of justice to the public. This is why, for example, oftentimes when there is a cop in a certain jurisdiction who is being accused, investigated, or charged with some sort of a bad shoot or misconduct in some way or corruption, we will bring in an outside agency. We usually call this a special prosecutor, but the idea is it's not that prosecutor investigating their own. It's somebody from outside the jurisdiction who comes in to investigate the situation and give a more neutral and a more unbiased opinion and make a charging recommendation. There's a reason we do that. It's to uphold the appearance of justice. And in cases where the appearance of justice is not upheld, it actually degrades the entire justice system. I want you to think about Alvin Bragg from New York. Do you remember this prosecutor? It's the prosecutor that went after Donald Trump. And when Alvin Bragg was running, he was running on the platform of elect me and I'm going to get Donald Trump. I'm going to get him. And people would say, well, you haven't even seen all the evidence, Mr. Bragg. In fact, it was confirmed he hadn't seen all the evidence of these purported felonies while he was platforming on getting Trump. And he said, no, I don't care. I don't need to see the evidence. I'm going to get Trump. And also those white-collar statutes that Trump was eventually charged with, it was kind of novel interpretations of those statutes that had never been charged to anybody in the federal system before. So that raised a few eyebrows. And then on top of all of that, Alvin Bragg's predecessors had actually turned down the case. They said, no, there's not enough for a crime here. Despite all of that, Alvin Bragg ran on the platform of I'm going to get Trump, charged him with those crimes and got the indictment, got the convictions. And what's the end result? The end result is the public's like, this is fishy. The folks on the right are saying this is really fishy to us. And this looks like a politically motivated BS prosecution. Now, when the folks on the left are like, how could you vote for a convicted felon? How could you possibly want a convicted felon in the White House? Alvin Bragg has given the right all they need to respond to that by saying, well, this is clearly a BS trumped up prosecution that has never been applied in this way to any other human being, and all the predecessors turned it down, and he was out there before the evidence came out. This is why maintaining the appearance of justice is so important. It actually hurts and degrades the justice system when the public loses confidence in their own justice system. This is not healthy for a society. So it is actually really unhealthy here, in my view, for the federal government to investigate the federal government and inform us with whether or not what the federal government did was right or wrong. They gave us their conclusion within hours of the shooting before the investigation. And I feel at this point, they're just saying, well, we're going to do the investigation now, but here's the answer we're eventually going to conclude in our investigation. We'll give you that up front, and now we'll do the investigation. Not good for the appearance of justice in the United States of America. And this leads me to some of the things that I just find so extremely troubling about the current narrative that the federal government is trying to frame around this entire incident. So within hours of this incident, Kristi Noem went on TV and said, here's what happened. A man approached federal agents with a firearm. Now pause right there. This to me seems misleading. This seems intentionally misleading. When you say that somebody approached with a firearm, that paints a certain picture in your head, and it does so very intentionally and purposely. This invokes images of somebody brandishing a firearm and bringing it in some sort of a threatening way towards the agents. In fact, he approached with a cell phone in hand and an empty other hand, and he was carrying concealed in his waistband. So even the way that it's framed, that the initial interaction is framed, looks biased to me. So then they said, yeah, it was very clear that this person was trying to do maximum damage to law enforcement. And he brought 2 magazines with him with dozens of rounds of ammunition. This guy clearly wanted to, they used the term, massacre law enforcement that day. Did you see that in any of the videos? I didn't see that in any of the videos. I think the videos very clearly show that Mr. Pretti never even touched his firearm and probably didn't go for it in any way, shape, or form, let alone was trying to massacre law enforcement that day. And in fact, if he was trying to massacre law enforcement that day, why not just take out the firearm and open fire into the law enforcement that was there that day, rather than to insert himself into this awkward scrum where he's surrounded by a bunch of people? This is not consistent with the conduct of somebody who would be out there just trying to massacre law enforcement that day. And the implication that the federal government is trying to draw desperately right now, which you should be offended by if you're a competent gun owner, is simply being armed. Simply being armed and having 2 scary magazines with dozens of rounds of ammunition imputes some sort of a bad intent, imputes to you, regardless of your intentions that day, that you were there to harm other people. Kash Patel then went on the TV and made the statement that nobody goes to a protest armed and with ammunition if they want to be peaceful. They're only going there if they have some sort of a bad intent to harm people. This is complete and total nonsense. I represent thousands of competent, responsible firearms owners throughout the United States. I've represented hundreds and hundreds of them in self-defense cases in criminal courts throughout the United States. I can tell you that many people choose to carry on a daily basis. Many of those people are politically active, and many of those people have gone to protests while armed. It does not express that they immediately want to cause harm to their fellow men and women who are present, or law enforcement for that matter, simply in virtue of the fact that they're armed and that they are carrying magazines with them. That is nonsense. It is offensive, and it's the type of language that I would expect to hear from a gun-grabbing administration. So all of you gun owners out there who prefer to carry while protesting, you are just characterized by this federal government as inherently dangerous, and we can impute some sort of bad intent to you. That should offend you. So now it is time for the Second Amendment community, the people who understand why the Second Amendment is so damn important, the people who understand that the original purpose of the Second Amendment wasn't for duck hunting, and it wasn't just for an individual right to self-defense. It was for self-defense against a tyrannical government. It's time to push back against this narrative right now, at this pivotal moment. And it's extra important to do this when it is defending the rights of people with whom you disagree politically. That's right, because if you sacrifice your rights, if you were to endorse such a ridiculous set of statements from the Trump administration because it's politically convenient for you to condemn what's going on in Minneapolis right now, trust me, history shows that will be used against you. If you are at a future protest and the government comes up and says, yeah, it's kind of the new standard now, your response can't be, well, hold on, that was just for them. I wasn't talking about me. I was talking about when people support political movements with which I don't agree. I'm not talking about me. When I want to carry, when I'm protesting and exercising my First Amendment rights, guess what? It's going to bite you in the butt if you give up rights to the federal government for political expediency. The Second Amendment should be a good reminder about a skepticism that the founders of this country rightfully had against a strong centralized government. That's the whole point of the Second Amendment. So regardless of how you feel about this shooting, whether you think that the agents were justified in shooting Mr. Pretti, or whether this was some form of unjustified homicide, in the very least, we as Americans should be able to converge upon the assertion that it is ridiculous to say that just because someone is carrying a firearm and possesses scary loaded magazines with dozens of rounds of ammunition, that in and of itself makes them an imminent threat to those around them. It's ridiculous, and we should very, very loudly reject such a concept coming from our federal government. You guys know at this law firm, we are pro-freedom, and I am very, very sensitive to erosions of freedom over time. And if you want to see the big pro bono fight that we are fighting against the federal government, who has been eroding Americans' freedoms through the Commerce Clause expansion over the decades, you should go and check out the video below, see what we're up to there. Now, if these agents escape any sort of criminal liability, the next question is, can they be sued civilly? The answer is maybe. And the issue is the same here, which is that the federal supremacy clause has the ability to take this thing up to the federal court, but it's not affected by the criminal pardon power at that point. So a federal suit, in theory, in a civil context for money damages, where the family is seeking some sort of damages against these agents, could in theory go forward. Now, I personally am very opinionated about the idea of qualified immunity. This is how a lot of bad actors have gotten out of any sort of civil liability. Bad officers, bad shoots, improper uses of force, a lot of times they are dismissed summarily because of qualified immunity statutes. I think in a perfect world, cops should be just as easy to sue as average citizens. Yeah, that's right, I said it. The concern here is that, well, if cops are constantly subject to civil lawsuits, they would never do their jobs properly. They'd be constantly terrified while they're out on the beat and not able to properly perform their duties to the public. I say those people aren't creative enough. In fact, I'm a lawyer, and if I don't represent one of my clients properly, I can be subject to a civil suit called a malpractice suit. And I've never had to use it, but I do have a malpractice insurance policy. That means that if I do something catastrophically wrong, I now have an insurance policy that can make the person that I have wronged whole again in a civil context. There's no reason why agents and police officers can't acquire malpractice insurance in order to cover their assets. But more importantly, what we really should be doing is using this as a national conversation to say, what should the standards be? We shouldn't have low standards for agents. We should have very high standards for agents. And so I'm very opinionated on these issues of civil liability, but in the world as it is right now, they very likely would have the opportunity to skirt any sort of civil liability because of these qualified immunity statutes. It's disheartening that we've had to talk about this type of an incident again in the last couple of weeks in Minneapolis, and my hopes are that both sides will see that their rhetoric, this inflammatory, incendiary rhetoric on both sides, casting the other side as evil existential risks, will calm the heck down, because the citizens are the ones who are losing as a result of this. Finally, I'm reminded to do something right now that Mark and I forgot to do in our Renee Good video. It's not that we forgot to do it, really. It's just that we thought that the point was so obvious that we forgot to make it. But that was a mistake, because we got a whole lot of new eyeballs on our channel from the Renee Good shooting analysis video, so we should have made this point. If you know anything about our firm, we run the Attorneys on Retainer program. This is a national self-defense program where the industry-leading program, if what you are looking for is aggressive representation in your self-defense case throughout the 50 states. So there were some questions on the Renee Good video. Hey, well, would you guys, if this guy was an AOR member, this agent who ultimately shot Renee Good, would you guys have covered him? And the answer to us seemed so obviously yes that we didn't even mention it. But I want to mention it here and say, yes, we would have covered him, and explain why. He fits all three of our very simple criteria. He is concerned that he may be charged, even though he hasn't been charged yet. But had he been charged, or simply being concerned that he might be charged in the future as a result of that shooting, check. He's claiming self-defense. He's saying the reason I shot her was in self-defense. Check. No problem. And then finally, had he been a member of AOR before the shooting? Check. That's all three of our criteria. Definitely would have covered the agent in Renee Good's case, just like in this case. Each and every one of these agents who is claiming self-defense, if they had been an AOR member, we would have covered each and every one of them. They would have fit all three of those boxes of criteria for coverage. And that means that they would have gotten 4 specialized attorneys at their felony trial. They would have had access to all of our national experts, and so can you. So if you haven't signed up for the Attorneys on Retainer program, if you're a competent gun owner, you're concerned you're going to have to use your firearm to defend your life or the lives of your family, don't hesitate to go check it out at attorneysonretainer.us. Learn all about our self-defense program. If you want to learn more about our law firm as well, I want you to go check out attorneysforfreedom.com. We're the law firm that specializes in self-defense, that services the Attorneys on Retainer program. But now it's time time to hear from you guys. We want your comments. We've been loving engaging with you guys in the comments section. Did I get it right? Did I miss something? Did I get it flat wrong? We want to hear from you. We want to do follow-up videos for all this stuff, so leave us a comment down below. And if you enjoyed the video, as always, leave us a like on the video, comment, subscribe to the channel, and share it with a friend. Until next time, this has been Attorney Andy Marcantel, signing out. Peace.